Today we're talking to Martin Checketts from Mills Oakley Lawyers about some of the legal aspects of buying and selling a financial planning business.
In many ways, a financial planning practice is a unique and challenging asset to sell. And one of the reasons for that is that what is really being bought and sold is the personal goodwill and the relationships of the seller. They've worked with the clients for often many, many years, and the challenge for both parties is to ensure that those client relationships are effectively transitioned to the buyer, and that the buyer keeps and retains the benefit of those relationships after he's bought the business. From a contractual perspective, a very important part of ensuring that the goodwill of the seller is effectively transitioned is the restraint of trade clause. So this is a clause in the contract which provides that for a certain period of time following completion, maybe it's 1, maybe it's 2, maybe it's 3, maybe it's even 5 years, the seller won't compete with the business, and or that he won't solicit or act for the clients of the business, and also perhaps that he won't solicit or employ the employees of the business in a separate venture. And this restraint of trade clause is often a fundamental part of the protection that a purchaser will require when buying the business. A few comments that I'd make in relation to restraint of trade clauses. Firstly, they're pretty interesting legally, because there's, if you like, a reverse burden of proof in respect of these clauses. In other words, it's up to the buyer, the person who's seeking to enforce the clause, to prove that the clause is reasonable. And if the buyer is unable to do that, then the clause will be void and unenforceable. So if you're the buyer or the buyer's lawyer, it's very important to draft the clause in a way that's going to maximise its enforceability. And in particular, to ensure that the clause isn't too widely drafted or the extent of the restraint isn't too broad or long, because that might give the seller some reason to argue that it's unreasonable and therefore unenforceable. From the seller's perspective, commercially speaking, I think it's really important to understand that restraint of trade can be a key sensitivity for the buyer. Where I've sometimes seen sellers go wrong is that they try and nickel and dime the buyer on the restraint clause. They try and negotiate various carve-outs. They try to significantly reduce the duration or the geographical extent of the clause. And all of these things can make the buyer extremely nervous. So my advice to a seller is generally to accept that if you want to sell for the best price, you really have to give a good and robust restraint to the buyer, and often that's a much better starting point for you than going in aggressively and then kind of being negotiated back from that position.